Hello everyone, welcome to my business law lecture series. Today we are going to continue the essentials of contracts with some case losses. In the previous class we learned regarding essentials of contracts, wherein which we have completed two major aspects, offer and acceptance and legal relationship, along with Balfour versus Balfour case. Before going to further, I'll narrate a small incident. Mr. Chintu, of 7 years old, wanted to join IPL right now. Is this possible for him? The answer is no. And Mr. Mintu, of 10 years old, wants to become a doctor right now and he is studying 23 hours a day. Is this possible for him right now? No. And this Mr. Pailwan wanted to become a weightlifter of 150 kgs. Is this possible for them? No. Can you tell me why the answer is no for all the situations? Yes, it's because of their capacity, which defines whether it is possible for them to achieve their goals or not. Like the same, we are going to fix the capacity for contract, which defines whether the parties can enter into contract or not. And this is called contractual capacity. The parties of the agreement must be capable of entering into a valid contract, and we must know who are the capable person or who are competent to enter into contract. Person has attained the age of majority. So here majority means the age of 18 years. Once they finish the 18 years of age, they can enter into contract. And the second one, person who is of sound mind. Is this the sound mind means making some sound from mind? No. It is the responsible person who can understand the terms and conditions of the agreement and who is not disqualified from contracting with any law. So in this particular case, for example, if we consider insolvent is disqualified from entering into any contract. So all these three situations defines who are competent persons to the contract. Age of majority or 18 years, who is having sound mind and who is not disqualified from law. And let us say one more thing, who are not competent to enter into contract. So which defines minor, with children we cannot enter into contract, with lunatics or idiots again we cannot enter into contract, and with drunken persons we cannot enter into contract. Even if we enter into these kind of people, and those contracts will become void contracts, which will not be having any meaning. Now, ಚಿಕ್ಕ 5-6 ವರ್ಷದ ಮಕ್ಕಳೊಟ್ಟಿಗೆ ನಾವು ಯಾವುದಾದ್ರು ಅಗ್ರಿಮೆಂಟ್ಸ್ ಅನ್ನು ಮಾಡಿಕೊಂಡ್ರೆ ಅಂತ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಏನಿರ್ತದೆ ಅದಕ್ಕೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಮೀನಿಂಗ್ಸ್ ಇರೋದಿಲ್ಲ. ಹಾಗಾಗಿ ಅದನ್ನು ನಾವು ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳಿ ಕರೆಯೋದಕ್ಕೆ, ವ್ಯಾಲಿಡ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳಿ ಕರೆಯೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. And the second one, citizens of foreign state, foreign sovereigns or government or artificial persons. We cannot enter into these kind of persons directly. Hope you understood the third essential of a contract, that is contractual capacity. The persons who is having the competence, the person who is having competency to enter into contract, and the persons who are not competent to enter into contract. And the fourth one, lawful consideration. So here consideration means quid pro quo or something in return for something. That means there should be something given and there should be something to be received. As per Section 23 of Indian Contract Act 1872, each parties to an agreement should give something and should get something. One person has to give something and another person has to receive something. So there should be some benefits to both, to all the parties to the contract. For example, Mr. Santosh will give pen to Mr. Dhanush, and in return Mr. Dhanush has given notebook to Mr. Santosh. So here Santosh has got the notebook and Mr. Dhanush has got the pen. So here both the parties have got something, and these articles which they received something is called as consideration. The parties of the contract should receive something, and what they receive is called as consideration. Suppose Santosh has given the pen to Mr. Dhanush, but Dhanush haven't given anything to Santosh. Is this called a valid contract now? Because Santosh haven't received anything, only Dhanush has received the pen. In this case, which cannot be considered as a contract, because there is no consideration for both the parties. The consideration is for Mr. Dhanush but not to Mr. Santosh. In that situation, we cannot consider the contract as valid on the ground of lawful consideration. Agreement without consideration is called as nudum pactum or naked agreement. You can see in this example. So here there is no consideration to Mr. Santosh. So in this kind of situation, we can call as nudum pactum or naked agreement. Agreement without any consideration. Again, the consideration may be in cash or in kind. That means either in the form of cash or in the form of articles or anything that is real or touch that we can feel. Or again, that might be in a form of kind also. For example, Mr. Santosh has given amount to Mr. Dhanush. In return, Mr. Dhanush has taught some maths to Mr. Santosh. Even then, we can consider it as a lawful consideration. But the thing is, both the parties should gain something, and this gain is called as consideration. And the second point is, consideration may be past, present, or future. For example, consideration may be past. ಸಣ್ಣ ಮಗು ಇರುವಾಗ ಆ ಸಣ್ಣ ಮಗುವಿಗೆ ಹೆಲ್ಪ್ ಮಾಡಿರ್ಬೋದು, ಅದನ್ನು ಕೂಡ ಕನ್ಸಿಡರೇಷನ್ಸ್ ಅಂತ ಹೇಳಿ ತಗೊಳ್ತೇವೆ. ಆರ್ ಕನ್ಸಿಡರೇಷನ್ ಮೇ ಬಿ ಪ್ರೆಸೆಂಟ್, ಪ್ರೆಸೆಂಟ್ ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಅವರು ಏನೋ ಹೆಲ್ಪ್ ಮಾಡಿರ್ಬೋದು. ಅಥವಾ ಆರ್ ಫ್ಯೂಚರ್, ನಾವು ನೆಕ್ಸ್ಟ್ ಅಪ್ಕಮಿಂಗ್ ಡೇಸ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಏನೋ ಇನ್ ರಿಟರ್ನ್ ಸಮ್ ಅಮೌಂಟ್ ಅನ್ನು ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳುವಂತ ರೀಸನ್ಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಏನೋ ಒಂದು ಆರ್ಟಿಕಲ್ಸ್ ಅನ್ನು ಕೊಡ್ಬೋದು, ಏನೋ ಒಂದು ಹೆಲ್ಪ್ ಮಾಡ್ಬೋದು. ಸೊ ಅಂತ ಎಲ್ಲ ಸಿಚುವೇಶನ್ಸ್ ಗಳನ್ನ ನಾವಿಲ್ಲಿ ತಗೊಳ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ. ಅದೇ ಎಲ್ಲ ರೀತಿಯಾದಂತನ್ನ ಕೂಡ ನಾವು ಕನ್ಸಿಡರೇಷನ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. Consideration must be real and lawful. It must be real and lawful. It cannot be some imaginary. For example, you might have read the book of Alchemist. ಅವರು ಏನೋ ಕನಸಲ್ಲಿ ಯಾರೋ ಬಂದು ಹೇಳ್ತಾರೆ ಎಲ್ಲಿಯೋ ಅವರಿಗೆ ಇನ್ನೊಂದು ರಿಟರ್ನ್ ಸಿಗ್ತದೆ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಹುಡುಕಿಕೊಂಡು ಹೊರಡ್ತಾರೆ. ಹಾಗಂತ ಹೇಳಿ ಕನಸಲ್ಲಿ ಬಂದಿದೆ ಅಂತ ಅದನ್ನ ಕನಸಲ್ಲಿ ಹೇಳಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ ಅವರು ರಿಯಲ್ ಲೈಫ್ ಅಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಫುಲ್ಫಿಲ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಆದ್ರೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅನ್ನು ಹಾಕ್ಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಐ ಪ್ರಾಮಿಸ್ ಮಿಸ್ಟರ್ ನೂತನ್ ಟು ಪೇ 1 lakh rupees ಇನ್ ಹಿಸ್ ಡ್ರೀಮ್. ಅವರ ಡ್ರೀಮ್ ಅಲ್ಲಿ ನಾನು ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ದೇನೆ. ಹಾಗಂತ ನೆಕ್ಸ್ಟ್ ಡೇ ನೂತನ್ ಅವರು ಬಂದು ನನ್ನ ಹತ್ರ 1 lakh rupees ಅನ್ನ ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಆಗ್ತದಾ? ಸಾಧ್ಯ ಇಲ್ಲ. ಇಟ್ ಮಸ್ಟ್ ಬಿ ರಿಯಲ್ ಅಂಡ್ ಲಾಫುಲ್. Consideration is lawful unless it is. So here the term lawful is defined here. So it should not be forbidden by law. And the consideration is of such nature, if permitted, it would defeat the provisions of any existing law. So anta considerations ಗೆ ಪರ್ಮಿಷನ್ಸ್ ಕೊಡೋದ್ರಿಂದ ಬೇರೆ ಯಾವುದಾದ್ರೂ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಲಾದಲ್ಲಿ ಅಫೆಕ್ಟ್ಸ್ ಆಗೋದಾದ್ರೆ ಅದನ್ನು ಕೂಡ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. It should not be fraudulent or involves injury to other persons or property, either to his proper person or to the property, is opposed to public policy. So public policy indicates, for example, in case of a library, so it is understood that no one should raise their voice. So if anything which violates such rules, so it is opposed to public policy. Consideration is lawful unless it is in these four situations: forbidden by law, and if it defeats the provisions of any existing law, or it is for fraudulent purpose, or involves injury to the person or property. For example, an agreement between A and B. The agreement is to spoil the car of C. So in these situations, the consideration is unlawful. If it involves injury to other person or property, it cannot be called as a consideration. And next one, lawful object. So here object indicates the purpose for which an agreement has been entered, and it must be lawful. ಯಾವ ಪರ್ಪಸ್ಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಥವಾ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನು ನಾವು ಆಬ್ಜೆಕ್ಟ್ ಅಥವಾ ಅಂತ ಹೇಳಿ ಕರಿತೇವೆ, and this object must be lawful. The object should not be, again, it should not be fraudulent, it should not cause injury to other persons or property, and it should not be immoral or against public policy. And the next one, free consent. The next one, free consent. So here consent means giving acceptance to the contract. All parties to the agreement must agree upon. So here agree means agreeing for the terms of contract, and same thing in the same sense. It means they should understand the terms and conditions in the same sense as it is being formed by other parties to contract. Their consent should be free from all sorts of pressure. They should agree or they should accept the terms and contracts without any pressure. So this is what about free consent. So here there are two major things. That means they should agree upon the terms of contract and understand the same thing in the same sense, and their acceptance or their consent should be free from all sorts of pressure. Any other persons cannot force the parties to the contract to enter into contract. So here Mr. Chetan and Mr. Nutan. So here in their contract agreement there is a term called fruit, but Chetan understood it as an apple and Mr. Nutan understood it as an orange. So in this particular case, if both the parties to the contract understood the conditions or terms of the contract in a different manner, they cannot move further. So for that reason, their acceptance or their consent should be free from all sorts of pressure, and they should understand the same thing in the same manner. And free consent should not be caused by coercion, like some threatenings. For example, ಇಂಥ ಪರ್ಟಿಕ್ಯುಲರ್ ಕಾಂಟ್ರಾಕ್ಟ್ಗೆ ಎಂಟರ್ ಆಗದೇ ಇದ್ರೆ ಸೊ ಕೆಲವೊಂದು ಹಾರ್ಮನ್ನು ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳುವಂಥ ಸಿಚುವೇಶನ್ಸ್ಗಳು. ಸೊ ಇನ್ ಸಚ್ ಸಿಚುವೇಶನ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಕಾಲ್ ಆಸ್ coercion. Undue influence. For example, Mr. Atik, and he wanted to purchase a Royal Enfield bike, whom he consult first, either father or mother. Definitely it is mother, but mother first influenced the father and then after, so he will consult the father. ಬೈಕ್ ಬೇಕು ಅಂತ ಅನ್ಸಿದ ತಕ್ಷಣ ಮೊದಲು ಅಪ್ಪನ ಹತ್ರ ಹೋಗೋದಿಲ್ಲ, ಮೊದಲು ಅಮ್ಮನ ಹತ್ರ ಹೇಳಿ, ಅಮ್ಮ ಅಪ್ಪನ ಹತ್ರ ಹೇಳಿ, ಆ ಅಮ್ಮನ ಇನ್ಫ್ಲುಯೆನ್ಸ್ ಎಲ್ಲ ಸೇರಿಸಿ ನೆಕ್ಸ್ಟ್ ಅವರ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನು ಹೇಳ್ತಾರೆ. ಸೊ ಈ ರೀತಿಯಾದಂಥ ಸಿಚುಯೇಷನ್ಸ್ ನಮ್ಮ ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ ಆಗ್ಲಿಕ್ಕೆ ಇಲ್ಲ. there should not be any such influence to enter into contract. It should be free from all such influences. Misrepresentation. So I recall the lines ಅಶ್ವತ್ಥಾಮ ಹತ ಕುಂಜರಃ. ನೀವು ಮಹಾಭಾರತ ಕುರುಕ್ಷೇತ್ರ ಯುದ್ಧದಲ್ಲಿ ಕೇಳಿರಬಹುದು. ಅಶ್ವತ್ಥಾಮ ಅಂತ ಹೇಳುವಂತ ವರ್ಡ್, ಆ ನೇಮ್ ಏನಿದೆ ಅದು ದ್ರೋಣಾಚಾರ್ಯರ ಮಗನಿಗೂ ಆಗಿತ್ತು, ಹಾಗೆ ಆ ಆನೆಯ ಹೆಸರು ಕೂಡ ಅಶ್ವತ್ಥಾಮ ಹೇಳಿತ್ತು. ಅದನ್ನ ಯುಧಿಷ್ಠರ ಹೇಗೆ ಯೂಸ್ ಮಾಡಿಕೊಳ್ತಾನೆ ಅಂತ ಹೇಳಿ ಮಿಸ್ರೆಪ್ರೆಸೆಂಟೇಷನ್. ದ್ರೋಣಾಚಾರ್ಯರ ಮಗನ ಹೆಸರನ್ನ ಬಿಂಬಿಸುವ ಲೆಕ್ಕದಲ್ಲಿ ಅಶ್ವತ್ಥಾಮ ಅನ್ನುವ ಆನೆಯ ಹೆಸರನ್ನ ಹೇಳ್ತಾರೆ. ಸೊ ಮಿಸ್ರೆಪ್ರೆಸೆಂಟೇಷನ್, ನಮ್ಮ ಒರಿಜಿನಲ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ಸ್ ಏನಿತ್ತು ಅದನ್ನ ಹೈಡ್ ಮಾಡಿ ಬೇರೆಯ ಥಿಂಗ್ಸ್ ಗಳನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡುವಂಥದ್ದು. ಸೊ ಇಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಫಾರ್ misrepresentation. Fraud and mistake. ಫ್ರಾಡ್ ಮಾಡೋದ್ರಿಂದ ಅಥವಾ ಮಿಸ್ಟೇಕ್ಸ್ ಗಳನ್ನ ಮಾಡೋದ್ರಿಂದ ಅಗ್ರಿಮೆಂಟ್ ಅಥವಾ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಗಳನ್ನ ತಗೊಳ್ಳಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಸೊ ಫ್ರೀ ಕನ್ಸೆಂಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಕಾಸ್ಡ್ ಬೈ ಐದರ್ ಆಫ್ ದೀಸ್ ಥಿಂಗ್ಸ್. coercion like threatens, undue influence, misrepresentation, fraud or mistake. Hope you understood the class. So let us have a small recap of today's class. So we learnt 4 essentials of a valid contract: contractual capacity, lawful consideration, lawful object, and free consent. Let's have a small quiz. Who are competent to enter into contract? The options are: person who has attained the age of majority, person who is of sound mind, person who is not disqualified from contracting any law of land. And the fourth option, all of them. So you can guess easily it is the option 4. All these 3 persons are competent to enter into contract. Lawful object of a contract implies the purpose of the contract, parties of the contract, preparation of the contract, and promotion of contract. Lawful object. The answer is the purpose of contract. Quid pro quo means lawful offer, lawful acceptance, something in return for something. Lawful object. The answer is C. Something in return for something under consideration concept. Agreement without consideration called as, the answer is nudum pactum. Quid pro quo means something in return for something. Nudum pactum, that means agreement without consideration. Lex mercatoria, that comes under source of mercantile law. Okay. Which of the following statement is wrong? Consideration may be in cash or kind. Consideration may be lawful or unlawful. Consideration may be past, present or future. Consideration must be real. The wrong statement is B, that is consideration may be lawful or unlawful. All the time consideration should be lawful. We cannot consider unlawful consideration. State whether this example is a valid contract or not. The statement is contract between A and B to destroy the car of Mr. C. The option valid contract or not a valid contract. The answer is B. So here, contract between A and B to destroy the car of C. The purpose or the object of the agreement is destroying the car of Mr. C. So, spoiling the other person's property is not a valid contract. So here are some references that you can go through for these things. Thank you for watching the video. Hope you enjoyed things and happy learning.